Ladies and gentlemen, I want to express a sincere word of thanks to the organizers of this conference. And I also want to say that I thought the sessions have been very interesting and debates over the last 2.5 days. So thank you for that. A special word of thanks to ASAP, or ASAP, as I think would also be a good way of pronouncing that probably, and Professor Poggi for inviting our institute to give a presentation. Thanks to you all as well, because it's a privilege to present our institute to all of you in this distinguished audience. The first session of the conference has made me even more curious about a roundtable that we will organize together with Professor Poggi at our institute on the 21st of November on illicit financial flows. And since those conversations and sessions have been so very enthralling and incredibly stimulating, I very much look forward to that. As said, my name is Jill, and I am a sociologist and a lawyer. So I beg your understanding for not being a philosopher. But I might introduce some issues that are a bit more legal or technically legal. I work as a researcher under the Rule of Law program of the Hague Institute for Global Justice. And we aim, as an institute, to bring the expertise of the international courts and tribunals based in The Hague to the field, but also to vice versa, seek to have the input of local context in their work. When I refer to the international courts and tribunals, I of course talk about the International Criminal Court, but also the institute hosted in the Peace Palace. And that has actually, it's been on the 28th of August that we've celebrated the centenary of the Peace Palace. So both the International Court of Justice and the Permanent Court of Arbitration being hosted in the Peace Palace. During those celebrations, we've launched what we call the Hague Approach, and I look forward to telling you more about that research project that we intended to have policy implications as well. But first, I'll tell you a bit about our institute. I shall limit this presentation to 3 points. But of course, I look forward to getting more questions if I haven't covered those. And that will start with a bit of a mission of our institute, then 3 projects under the Rule of Law. I'll mention the other ones, but since I work under the Rule of Law program, I thought it would be better just to focus on those. And of course, the kind invitation of Mr. Cabrera to discuss about positive impact on poverty alleviation, policy and practice in a broad sense. I have interpreted that broad sense to also encompass the rule of law, and I construed this theme by connecting access to justice as a means to assert rights, economic rights, in a positive impact in that broad sense. So hoping to have done that correctly. My first point, the Hague Institute for Global Justice. We intend to be a think and a do tank, which means that we aim to become a recognized national and international think tank for innovative applied research. Both policy development is another aspect of our work, and professional skills training on issues of peace, security, and justice. We are independent and nonpartisan, and our work centers on, broadly speaking, 4 types of activities. So interdisciplinary policy-relevant research, practitioner training, facilitation of activities using our convening power in The Hague, and by all of these attempts, and mostly that in conjunction, of course, to promote conflict resolution and global justice. As an example of trainings that we give to practitioners, that is a broad range of practitioners, including, for instance, NGO activists from Zimbabwe, as we did last week. And in terms of facilitating of activities, we also have a distinguished speaker series ranging on, we have several topics, and one of those will be, or our first will be Sir John Holmes, to be talking about humanitarian aid. Finally, by all of these aforementioned activities, we promote conflict resolution and global justice. And under conflict resolution, we include conflict prevention as an inherent and integral theme. We all know, of course, that one of the major sources for a lack of economic development today is the existence of violence. And one of the great development challenges of our time is to help countries afflicted by conflict and fragility to find a path towards sustainable peace and security and development. So, for instance, the World Bank Group has set the twin goals of ending extreme poverty with a generation and boosting shared prosperity in all countries. Reaching those goals means sharpening the focus on the world's fragile and conflict-affected situations. And fragile and conflict-affected countries are the most challenged in the developing world in meeting the Millennium Development Goals, discussed so many times, a deadline which is of course now less than 1,000 days away. So our institute seeks to promote conflict resolution through law and the prevention of conflict, law in the broad sense, so also alternative dispute resolution mechanisms. And in doing so, we promote the prevention of conflict in its initial occurrence, but also its reoccurrence, and have regional foci as explained on this slide. Well, my second topic is how we work, and especially our three broad themes. So to say, conflict prevention, rule of law, and global governance. I shall briefly mention a few of those flagship projects of all three programs to give you an overview of our work. And I can only mention those in some small terms, and then I'll talk a bit more about the rule of law program under which I do most of my work. Well, under conflict prevention, we currently have three branches of policy-relevant research and other types of activities. First, we focus on responsibility to protect. Second, we have a project on the prevention of climate change-induced conflicts. Third, we have a diplomacy and other conflict preventive measures being dealt with in relation to natural resources, and particularly with water. Our institute, for instance, works in water diplomacy in a consortium with partners, and those are the Netherlands Institute for International Relations, Klingendael, Water Governance Center, UNESCO IHE, Institute for Water Education, and the UP Center in The Hague. The other program, the Global Governance Project, or the Global Governance Program, has three projects that I shall mention. There's a few more, but the three flagship projects are the following. We've mentioned the World Economic Forum, or the World Economic Forum was mentioned already, and of course also the Global Risk Report of 2012, so I wouldn't have to elaborate on the fact that global governance failure is ranked as a global risk that is at the center of many other risks. Now, what is that we do on global governance? First, we have a project called the Forum on Global Governance Reform that focuses on improving governance, global governance, in diverse areas that we label as have no passports, i.e. the areas of cyberspace, migration, and oceans. Second, another project regards intellectual property regimes in the fields of medicine and agriculture. Finally, we currently conduct a feasibility study in order to determine whether we should also start a center on social justice, a center of excellence. Now, under the rule of law, which is essentially the program that I work most under, I already mentioned the Hague approach. The Hague approach it comprises two empirical studies. First, we had a comparative study of rule of law initiatives by senior international rule of law experts in Afghanistan and Iraq. And second, we had a study focused on rule of law in post-Gaddafi Libya, jointly carried out by researchers from both Leiden University, the Van Vollenhoven Institute, and Benghazi University, a local university in Benghazi, the region of Libya. Drawing on the finding of these studies, the Hague Institute launched the Hague Approach, which are 6 principles for achieving sustainable peace in post-conflict situations. And this set of principles aims to provide policy-relevant guidelines for host country governments, civil society, donors, and international organizations engaged in peace-building activities. Drawing both on field research on the one hand and a desk study of ongoing peace-building processes and initiatives, the Hague Approach seeks to harness innovative thinking in the peace-building community and crystallize lessons learned. By reconceptualizing the peace-building enterprise and identifying new trends, it seeks to do 2 things. To address, 1, long-standing peace-building challenges by reorienting thinking and practice, and 2, to address new peace-building challenges which have emerged as a result of geopolitical power dynamics and a changing constellation of stakeholders. We have drafted 6 guiding principles for achieving sustainable peace in post-conflict and conflict-affected situations. Oh, so sorry. These were the Apparently I've missed a slide. Well, it's not on here. This is the cover of the book. The principles are prevention matters, fostering a rule of law culture, a network response, private sector engagement, strategic communication, and a responsibility to learn. All principles include practical tools and policy recommendations. So to combine some of these, to give you an overview, we looked at the issue of ownership, local ownership of peace-building activities. Building on the principles underpinning the New Deal for fragile states, the Hague approach considers not just the challenges of conflict settings, but also the practices of peace builders themselves as individuals and representatives of organizations. The emphasis is on responsible conduct and peace-building practices that are based on genuine two-way communication. This is what we label as strategic communication, and for those to be responsive to locally defined needs and priorities. Research from Libya presents a case of a country which inverts the typical model of the international community, indicating its priorities to a host government. In Libya, on the contrary, the host country government has specified to the international community what kind of assistance it requires. And that typifies a demand-driven approach which is likely to gain salience as the New Deal develops. Well, under this project, we've triangulated 3 methodologies: case studies, a governance study, and a general survey amongst the population. Case studies were done by the method of following the justice seeker, so looking for legal problems that emerge within the context of a typical Libyan situation, and then, or for a Libyan person, and follow the route he or she takes throughout either the informal or the formal legal system. A governance study was also undertaken, and that was mostly to identify the current governance structure within Libya, its institutions, the constellation, the interrelationships between all of those governing bodies. And thirdly, we had a general survey amongst the population, more or less to specify the most important needs in terms of justice of the Libyan population. Now, to tell you a little bit about the other aspects of responsibility to learn and fostering a rule of law culture. We felt it was important to go beyond what are traditionally the institutes and procedures of law, but actually look at culture, legal culture. Rule of law being, of course, a notion of principles, somewhat diverted by the 2 terms, either in terms of rechtsstaat, which is the German word for a law of rule of law culture state, or rule of law culture as principles of natural justice, more known to the common law lawyers. Institutional learning is often identified as a priority for peace-building actors, but rarely happens in practice. So we've done as a field research component of the Hague approach to identify deficits of knowledge about local contexts and inadequate partnerships between external actors and local experts as key peace-building challenges. The partnership between that center, VVI, at Leiden University and Benghazi University that resulted from this project exemplifies such sustainable capacity building that harnesses local knowledge and, in the long term, the kind of cooperation necessary to enable peace builders to carry out effective analyses of local conflict and justice landscapes, which will then inform peace-building activities. Currently, there's an exchange program between both universities for Libyan students to attend university lectures at Leiden University and vice versa. I shall also briefly mention 2 of the other projects that we do under the rule of law. So looking at this slide, this is our objective and thematic focus. And one of the key projects I've just tried to explain. We also have 2 other flagship projects that we currently run. There's the Model Code for the Investigation and Prosecution of International Crimes, quote unquote, the crimes currently listed in the Rome Statute. First, we have a project on, we are working with a group of experts on a model code for the adjudication of such international crimes in domestic legal systems. And working across the civil law, common law divide, we hope to ensure effective investigations, prosecutions, and adjudications of the crimes under the Rome Statute. And again, we translate such activities under this model code project into capacity building activities and training, more specifically. We also have a project on harmonizing evidence or materials gathered by inquiry commissions, mostly set up by the UN, but not necessarily so, that might be used, such materials might be used in international courts and tribunals when prosecuting such crimes. And we've already provided trainings on international criminal law and transitional justice in national jurisdictions, sometimes inviting, for instance, Libyan judges and prosecutors to come to The Hague and also see the International Criminal Court and its dealings and the other courts and tribunals, but also sometimes in the field. Now, coming to the third part of my presentation, we are working on our method of monitoring and evaluation right now. And with regard to our impact, we work on several fronts. So for instance, under that fostering of a rule of law culture I mentioned as one of the Hague approach principles, we also have explained tools, practical tools, and policy recommendations that could be followed by those, by our audience. So what we've done is, for instance, identify peer-to-peer knowledge sharing among local and international peace builders who share the same or similar professional backgrounds in the rule of law to help them crystallize and disseminate what they have learned. Another aspect has been comprehensive legal education, building on domestic capacity by teaching local law students and legal professionals about national law and local customary law, as well as international legal standards and principles. For instance, legal aid clinics allow students and professionals to gain valuable experience while providing specifically vulnerable groups, or sometimes called marginalized groups, with legal services at little or no cost. Other types of tools that we've put forward are education about human rights, access to justice, and legal aid programs that can help to empower vulnerable groups to, on the one hand, ask for such services of their government, and also to hold the government accountable under the law for providing such services, but also to abide by the law themselves. So for instance, delivering legal aid alongside non-legal services, such as education or midwifery, allows vulnerable groups to obtain such aid easily and inconspicuously. Specific tools for reconciling formal and informal justice systems include, for instance, a recording of decisions made in informal justice systems to establish legal precedents and ensure that the outcomes are consistent and predictable, one of the major difficulties of informal systems as we speak. Also, creating typologies of cases that can be channeled through either the informal or the formal system is one such tool. And using formal systems as appeal courts for informal ones makes it easier to bring informal judgments in line with international standards and principles, but also to enforce them. We've also incorporated aspects of informal systems favored by local people, for instance, in the area of restorative justice and economic compensation, into formal ones. Coming then to some of the policy recommendations, fostering of a rule of law culture, for instance, throughout the peace-building process, has been on the basis of devising initiatives that are consistent with international standards, but specific to the local context. To consult with local stakeholders, including those who hold moral authority and can facilitate change, as well as vulnerable populations, to design measures that respond to local needs and build confidence in the rule of law. But also to avoid double standards. International actors must, of course, respect the rule of law at the international level if they are to be at all credible in urging accountability and transparency of legal systems at the national or subnational level. Now, in terms of impact and its measurement and our Institute's positive impact on poverty alleviation policy and practice in a broad sense, most of our projects are funded by external financiers. And we believe that such funded projects also help in determining our impact, as well as in evaluating our processes and results. And we think our work in the area of rule of law is important, if only because, for example, the OECD has estimated that by 2015, half of the world's people living on less than $1.25 US a day will be in fragile states. While poverty has decreased globally, for all of the reasons we've mentioned, but we also have noticed that progress on Millennium Development Goal 1 is slower in fragile states than in other developing countries. Since fragile situations as a notion became a central concern already in the international development and security agenda around the 1990s. And since then, powerful forces have been influencing the causes and manifestations of fragility, including the combination of democratic aspirations, new technologies, demographic shifts, and climate change. And the last 5 years have been especially tumultuous, at least in the focal areas that we've identified, encompassing the 2008 food, fuel, and financial crisis, and the Arab Spring, or Arab Vivaldi, the Four Seasons, as it's also been called, which began in 2011. For this same reason, we work on conflict prevention, rule of law, and global governance. Summing up with yet again 3 points. I've been consistent with my 3, I'm afraid. We aim to diversify different means of reaching different audiences with tailored messages. So our projects range. We have books, policy briefs, online commentaries, podcasts, etc. We also try to amplify mostly local voices of, for example, the Libyan research partners that have to be heard by a larger audience. And in this we take into consideration the important conclusion, at least as I've understood it to be from most, at least behavioral economic research, that perceptions prove to be a poor predictor of behavior, so that it's very important to look at behavior per se. And we combine the types of activities to unite and reinforce impact. So those were the activities of interdisciplinary policy-relevant research, practitioner training, facilitation of the activities and our convening power, but also to promote, by the combination of all of this, conflict resolution and global justice. I thank you for your attention.